and the juvenile court issues specific steps outlining services required for reunification. Then ultimately, all decisions made by the department are overseen and approved by the juvenile court. No one person or entity can make a major decision in the case without all parties, which often include professional clinicians, being heard. Allowing one clinician involved in a case to require reunification would dismiss the opinions and wishes of all other parties and possibly lead to unsafe outcomes for children. Therefore, we are opposing it. Thank you for your opportunity for us to testify this morning.
Thank you so very much. Thank you for that testimony that does give us some insight, but I do have a couple of questions. Let's begin with bill number 5853, which is the disclosure of certain records by the Department of Children and Families. In your testimony, you had stated that there are certain instances when that is already allowed for that information to go to be accessed by the judiciary. So, but in your testimony, you didn't mention what those are. Can you just name a few of them that would fit under the definition of what you said?
Sure. When children in our care, older youth in our care are involved in locked facilities and in detention settings, information related to those children who are in foster care can and often are shared with the judicial branch and with the Department of Correction if they're locked in the Manson Center ran by the Department of Corrections. That information usually is educational information of our children, mental health information, treatment protocols, diagnostic information, so that continuity of care can occur for those children when they're placed in those settings.
Thank you very much. And I had a conversation with a good representative who wrote this bill, who sent this over. And one of his concerns is that in previous years, there was a group or a program which would identify families who have service needs if they are arrested or something before adjudication, and those families would then go to this group who would help provide services, because there's always, when we're talking about juveniles, there's always that question of, is this someone that should be incarcerated or is this someone who should receive services? But I was told that that group is no longer in existence. Unfortunately, the representative did not give testimony today, and I had hoped that he would, so that I would know exactly the group that he was talking about. But do you know what he was talking about, why it's not there anymore, and is there something else in its place?
It sounds similar to a consent decree that we entered called the Emily J. Consent Decree, which created a protocol that upon arrest of a juvenile, the Department of Children and Family, we would have liaisons in detention centers who looks at all arrests the morning after to determine whether or not any of those children that's been arrested the day before are in our care and custody as foster care. And if so, it triggers an immediate notification to the caseload carrying social workers and their chain of command that your child has been arrested. And then that enacts what's called a CRT, which is a case review team, which is made up of the family, the foster family. If it's an open DCF case and it's not and the child is not committed, then their parents, their bio parents have custody, the court personnel, and a whole host of folks from multidisciplinary perspectives coming together immediately to put together a diversion plan, if you would, for that child that could meet that child's needs rather than going further into a locked situation. That plan then is put before the court. The judge looks at it and obviously asks everyone who's a part of it whether or not they are committing to do their part. And based on those commitments and the solid nature of the plan, the judge can divert and send the child home with that plan in place. That protocol was in place for several years, and it expired because we were successful in meeting all the goals of that consent decree. Vestiges of it has continued, but the immediate case review process has not. And we've had conversations with judicial about resurrecting that because it is something that we both realize that we need to do.
Are these discussions ongoing?
They are.
And so this could potentially come back. I mean, it's obviously works. This could potentially come back. And if that happens, would that fit under this legislation in that it's happening the way this legislation is almost intending to happen, if I understand the legislation correctly?
Yes, it can. And we've started the conversations with our partners at CSSD to resurrect that protocol. We hadn't gotten there yet. There are a lot of other areas, and we realized we probably need to tweak it and make it more modern to today's times, and look at how information is shared timely. It's not a prohibition of sharing information. It's just a timeliness of getting information, both from, reciprocal from us to them, them to us, to assure that the best decision for a child is made upon that child's arrest.
Thank you very much. And so hopefully we can move forward and have those discussions. It sounds like it really was a great, effective program that's in the best interest of all involved. So I hope we do continue that conversation. Just one last question on this bill before I ask another question on another
Sure.
bill and then send it to my co-chair. Is there currently language or any instances that you're aware of that would require or are happening during civil cases where there is disclosure of records through the Department of Children and Families of anyone with an open case, not just someone that is a member of the foster care system? Is there any mechanism by which those can be requested and not necessarily need a court order to receive?
Without the written consent of the parents authorizing the release of that information, I'm not aware of any other mechanism that can do it, because the privacy laws do protect those individuals for sharing their private information without their consent.
And can you think of any time when that should be available for a civil matter?
Without the consent?
Correct.
It's hard to think of one. Right now, my mind goes blank.
Nothing you can, because
Nothing that come to my attention immediately.
let's say the safety of the child is at risk, and there's some civil proceedings like a divorce, and there's belief that a child is at risk. If it's a divorce and the two parents are in there, does the one parent who is not who is like fighting for custody, I'm really giving you these weird things, but
these
who
are
is
real
fighting
things.
for custody, because they are both parents, do they already have access to those DCF records if there is a case?
They have access to the record of their child, yes.
Okay, great. Thank you very much. Those are the questions I have on that piece of legislation. The other one I would like to talk about as quickly as I can is really about the Foster Parents Bill of Rights and staff turnover reduction and bias training. Let's start with the bias training. For that bias training, can you please explain briefly what bias training does? Essentially, is it to check your bias as a and recognize it as a employee, or is it training to recognize bias in others?
For the department, the journey we've been on to address issues of implicit and explicit racial bias within the Department of Children and Families has been one that does three things. It is to unearth personal implicit bias so that people can be aware of their personal implicit bias. And all this is at the first stage, which is consciousness raising, because the awareness stage is the first stage. Most folks are not aware that it exists. So we do it at the personal level. Then we do it at the institutional level. So that people can look at the policies and procedures that exist within our department that may have embedded within it issues around racial bias that creates inequities across racial and ethnic minority groups based on our decision-making about it, who gets substantiated on, who gets removed, who gets reunified, who goes further into our system. And then thirdly, we look at the structural biases, and that's how we partner with other state agencies like housing or judicial or TANF agencies. And those relationships create a structure. And within that structure, there are biases that exist implicitly, some even explicitly, that we have to deal with. And so it requires us then from a consciousness raising level to set up some strategies on how we deal with it. And for the personal bias strategies for individuals who work with us to go through a series of trainings, a series of coachings, things like that. And for the institutional, we have folks, we have work groups and a statewide work group that looks at this, that often have folks putting together strategies, that gets tested in a process that we call PDSA, Plan, Do, Study, Act, which is a cyclical process that we put in place on areas. For instance, if we say we see implicit and explicit bias in our substantiation rate against people of color, then we say, then what can be done? What's a strategy we can use? So we plan it, study it, do it, and then act, and then we keep doing it until we see that it works. And then for the structural piece, it requires us to develop partnerships with our other agents, our sister agencies around this issue, and begin to develop plans and strategies to see how we can work better among us structurally to eliminate inequities that exist in our system due to racial bias.
And that all sounds fantastic. Thank you. But I guess what my question is there training for managers to recognize bias in the people, the caseworkers that are working underneath them, so that they can recognize it within their ranks?
And within the Department of Children and Families, we have an Academy of Workforce Development that does the onboarding training, but also ongoing professional development. And within our professional development curriculum is that particular training around supervision with a racial lens, coaching with a racial lens, and putting a racial justice lens on all the work and activity that we do. That's a part of our ongoing work at the department through our Workforce Development Academy.
I think that's fantastic. Thank you. But everything that you're talking about you're saying about racial bias. I'm just wondering, is there also training regarding sexual orientation bias, LGBTQ, making sure that we have enough foster families that are same-sex couples, and that children in the foster care system who are LGBTQ are treated appropriately and placed with foster families that would support the children being who they are?
There is. We have really elevated our practice with LGBTQ communities to the point where we're now developing a practice guide, which we have in most of our work. Like in our fatherhood work, we have a practice guide. Likewise, in this, it's a practice guide to show all of our staff and to help all of our staff understand decision-making. And most importantly, is embedded in our curriculum with our foster parents when they're being trained and licensed to understand the unique needs of the LGBT community and how to respond to those needs, and the service delivery system that exists that is uniquely designed for that population of children that happen to be in our care. We have several contracts with service providers in the community who are brought on board for that very purpose. And then in our youth advisory board, we have the focus every year, along with other New England states. Our youth gather together to determine what are the priority issues for the year. This year, the priority issue is around the practice with LGBTQ youth, and Connecticut's youth is the leader in that New England consortium of youth and foster care, who's driving not only state policy, but national policy as it relates to practice, child welfare practice with children who identify as LGBTQ.
I'm not only pleased to hear that, I'm proud. So thank you very much. Those conclude my questions. Senator, do you have any follow-ups?
No, just to say that thank you for your explanation on bias training and the ways in which it's been incorporated inside inside DCF, because it sounds very comprehensive.
It is. It is. Thank you.
Thank you very much, Senator. Representative Dauphiné.
Hi, thank you, Madam Chair. My question is specific to the proposed bill 5853. You talked about a protocol or a program that was in place earlier. Did you say it was Emily, or can you repeat the name of that protocol that no longer exists?
It was a consent decree that the department that the state entered into called the Emily J. Consent Decree.
Okay. If we passed this bill, would that be something that would help initiate that program again? Because it sounded like what the legislator that I know put this bill in was looking to do is to better understand the juvenile that was before them in areas where they weren't able to have access to that information, so that they could better direct their services in a way that was constructive. That's how I understand it. Is that program being reinitiated something that would help, and would the passage of this bill help, put that program back in place?
Yeah. We would need to hear a lot more detail about the bill on its surface. The concept seems to resonate with us. The ability to instigate timely information sharing is what is now upon us, not necessarily the sharing of information, but to assure that all agencies that are working with children have the ability to, particularly children in our juvenile justice communities or in foster care, have the ability to share information on a timely basis. And if this legislation does that, that would be a great help. But unfortunately, we don't know much more about it than what's on the surface right now.
Yeah, thank you. I understand. I think that was the intent, but I understand that there's, lack of information here. So thank you. Thank you for your testimony. Thank you, Madam Chair.
Oh, you're very welcome. Thank you very much. And this has triggered a question from Senator Mar.
Thank you. On bill number 479, where it says that families may be reunified with a parent if a licensed psychologist recommends reunification. Is there a reason why we would not also include a licensed social worker?
We are not in support of that bill as written. We believe that it has to be a more dynamic process with many other factors other than the evaluation of a licensed clinician. And that licensed clinician can be a licensed social worker as well, which we often use in making reunification decision. But it's one of many factors that we use and that the court looks at when a decision to reunify a child with their families occur. What the proposed bill was saying is that it becomes the only factor, and we are saying that that's something we would not agree to.
Thank you.
Thank you very much. Representative Master Francesco.
Thank you, Madam Chair. Thank you so much for your testimony. This is the first time I'm on this committee, so I find it very educational and I appreciate your testimony. Did you by any chance submit your testimony so we can see it online? If not, would you mind submitting it? I don't
believe
see it
was.
here.
Yes.
Is it?
Representative, yes, it's there. And there's an email with a link to the testimony for everyone to look at. We're trying to be green here in this.
Thank you. Thank you. I appreciate that. I just had a question for you on the racial bias training. That training is for staff.
Currently, we do it for staff. We just stood up in our department very recently a community provider academy to begin to migrate out our trainings that we do internally to our community providers, particularly as we are implementing our family first work, which includes prevention, a huge upstream prevention efforts. In order to do that well, we have to include our providers in it. And we just created a practice model around safety that internally we all are trained on, but now we're putting it out to the community to train our community providers. So within that provider academy, if you would, is a curriculum of things that we do internally, offer to them externally.
So for your providers, which is good, is there a fee that they pay the providers that to get that training?
No, we don't charge.
You don't charge,
No.
okay. And then, I'm just curious to kind of give me an example so I can understand a little bit more about the training. When you say racial bias, can you give me an example of maybe something that has happened in the past that would trigger more additional training on that?
Well, we have quite a few cases that we spend just tremendous amount of time learning from, where we make a decision around either a removal, if you will, and we ask the question in real time: would this removal have occurred if the family racial presentation was different? If the family zip code was different, if their economic status was different, did any of that impact our decision around the removal of a child, to assure that we are not removing or having unequal lenses around what it takes to keep children safe? Because what we've learned, particularly in this time of an opioid epidemic, that there also was underreporting happening due to racial bias, that people believing that folks in rural and suburban communities were keeping their children safe when they were struggling with an addiction, and they really weren't, and was not reporting that, compared to reporting on urban communities of families who may have tested positive for marijuana only.
So if I'm understanding correctly, so there would maybe children be removed from a foster home because the foster parents have a racial bias? Is that
Oh,
basically?
no, I'm speaking from their biological homes. When we bring the children into the custody of the Department of Children and Families, that particular decision point is the point I was making around where racial bias gets examined in our practice, and that we learn from our work there whether or not we are operating with implicit or explicit bias, or are we doing this from a racial equity perspective.
But I guess I'm still not understanding it. How do you make that determination to remove a child from a home based on racial bias? I'm just trying to understand, to get an example.
No, it's after the fact. It's a learning piece. Whenever cases come before us and we have to learn from them. For instance, our data will show disproportionality and disparity around racial and ethnic minority lines, right? We may show that Black children are 2.5 times more likely to come into foster care. Our Latino children are 3 times more likely than white children to come into foster care. So we have to examine what's the cause of that. Is it because in their communities, there are a lot of other factors that contributes to them being unsafe that requires us to bring them into foster care? Or is there a racial bias existing, or some implicit bias existing in our practice that would make us quickly bring a child of color into foster care than a child who's white? Not to say that it happens in all cases, but it's a data point that we have to constantly look at to assure that we have racial equity in our practice.
Okay, I'm still really not understanding it 100%. Just give me 1 second. I'm
Sure.
just trying to understand. So it has nothing to do with removing a child from a home because of racial bias. Because when I hear the word racial bias, I'm thinking that, gee, this child is in a home where the parents are, or the foster people are, they're biased. They discriminate. So when I hear racial bias, that's what I'm thinking. And yours is more of just a study based on the community that they live in, to
And
assume that because maybe they're in a depressed area, a certain demographics, that it's racially biased.
And what I'm
because of
describing
that.
is not our assessment of the parents' action. It's the assessment of our actions, the workforce, our social workers' action. Did the social worker make a decision to remove a child based on a bias? Or was the decision made in a racial equity way, not the foster parents.
Okay. Okay, well, I would assume that if they were in a good foster parent and they're taking care of the child, and if somebody in your department removed them because of their personal opinion based on racial bias,
Mhm.
that's not good for the child or for the
Correct,
people that are taking care of them, because they could be under very good care.
correct.
And based on somebody in your department's opinion of using racial bias is not a reason to really remove a child unless there's obviously evidence of that.
That is correct.
That's
And-
great.
And I
Okay.
think that's the intent of the legislation.
Gotcha.
proposed
Okay.
Legislation.
Thank you so much. I appreciate you clarifying that for me. Thank you.
Thank you very much, Representative. Representative Comey.
Hello, thank you, Chairwoman. Deputy Williams, thank you so much for joining us, and my apologies for coming in a bit late and maybe missing a little bit of your testimony. But my question is, we're talking a lot about how you evaluate, your actions as an agency or as people in the agency. I'm wondering if there is a process for foster or adoptive parents who feel as though they have been impacted in some way, whether in a decision-making, from the agency, by bias of any type. And, what is that process? Is that an internal process examined, or, are there other effective means to be able to listen to the concerns of the foster or adoptive parent?
Sure. There are several processes in place and structures in place that we have in the agency to make sure that the voice of our caregivers is heard loud and clear. First and foremost, every child that's placed in a caregiver's home, a licensed caregiver's home, that caregiver has a support worker and a whole support staff apparatus, a chain of command, who's dedicated solely to them. This is not the workers for the child or the child's bio family, but these are individuals who we hire to be the support for the caregiver, their own personal support persons. And oftentimes, if there is a sense from a caregiver that the social work staff for the child are making decisions that's not right, or they disagree with, they can go to their support worker. That support worker can take that to their office leadership, and that creates what we would call a case conference for folks to come together to examine whether or not the decision is the right decision based on the foster parent's voice that was aired in that situation. So that's one immediate avenue that's open to them. The second is that we have a very comprehensive and robust ombudsman system that our foster parents know very well. And that is a system at the commissioner's office, in the commissioner's level. Actually, Ken Meisegland, who's here with us today, is the person who's responsible for the staff who runs that system. And that's totally disconnected from the office where the case may be happening. And foster parents, constituents, anyone can call that system, call that part of our agency, lodge their complaint. Those complaints are formally lodged with resolutions documented as to whether or not their complaint has been resolved. The ombudsman staff get, everyone involved who the complaint is made about to hear what it was and to offer a formal resolution in writing for the complaint that was made. So we think we have a good set of avenues available for our caregivers to offer any kinds of complaints and concerns that they have. But I can share with you, caregiving, being a licensed caregiver is probably one of the toughest jobs there is, because you're caring for other folks' children. And when you do that, you bond and you fall in love with these children, which is what we want them to do. And at times, what we expect, they have more information than we do. They see the children every day, every night. We may see the child once a month, and they have more information about a child and about that child's family than our social workers do. And so we have to make sure we hear their voice when it comes to reunifying when it comes to moving them to another foster parent or to another adoptive home. We want to make sure that voice is there.
Thank you. So to clarify, you're saying that there's a social worker
Mhm.
Who provides the direct service to the child, and then there's a support worker,
Right.
which is maybe that person's supervisor or in a
Right.
different sort of role.
So you're correct. Our structure is that for foster parents, our licensed caregivers, there's a chain of command that exists of a social worker who meets directly with the caregiver. That social worker has a supervisor, and that supervisor has a manager. And then for the child who's placed in the foster home, that child is a part of their biological family's case. That case is managed by a social worker, a different social worker who has a different supervisor, who has a different manager dealing with the child protection issues on the case.
Thank you. Thank you for sharing. Thank you, Chairwoman.
Thank you very much, Representative. Representative Wieslander.
Thank you, Madam Chair, and thank you, Deputy Commissioner Williams. I had just a sort of a personnel question about Raise Bill 480. Is the hiring for the agency done through DAS, or does DCF do the hiring on its own?
So we are part of the centralization that occurred
Mhm.
to where now Department of Administrative Services is the lead agency for the hiring process for social workers and all state employees at this point.
Thank you for clarifying that or confirming it. I know that as we move forward in the, technology age, we're trying to simplify things and create, what's the word I'm looking for? Oh, it's already been a long morning, but we're trying to streamline things as much as possible.
Mhm.
But do you, and just, this is maybe an opinion question, which if you don't feel comfortable answering, I understand, but do you feel it would be easier for the agency to track the positions that they need, recruit and retain social workers, staff members, and case managers if the agency was able to do it on its own rather than through another source?
Because centralization is still relatively new for us. There's a lot of wrinkles that need to be worked out. I see the merits of it. We have had our frustrations in the past as they are getting better to meet the needs of the state agencies. But my side of the operations is the operations, the day-to-day work. There's another deputy who's in the trenches on that, and she probably could better answer that question with an opinion that makes more sense than mine and the commissioner as well.
If they are willing to have a conversation, I would love to hear about that, just to make sure that we can support you and the agency as much as we can. And because in turn that supports the families and the children.
Yeah, I'll share that with them.
Thank you very much for your time. Thank you, Madam Chair.
Thank you, Representative. And we're going to circle back now to Madam Ranking Member, Representative Daphne.
Thank you, Madam Chair. Just hopefully this is a quick question. I just wanted to understand SB 479 a little bit better, and reading some of the testimony. It seems as though it was put in based on some cases where reunification didn't happen in a timely matter once the psychologist recommended reunification. So I just wondered if you could speak to that, because that seems to be what this bill is based on, is pushing that through quicker and maybe having some timelines with regard to that and getting the families back together once it's recommended versus it dragging out. So could you speak to that a little bit?
Sure. It's a great question. A psychological evaluation usually occurs at the time when contemplation of reunification is happening. But it's only one factor that we use to determine whether reunification happens. What a psychological evaluation does for us, is the ability to look at the protective factors that a parent or parents may have for their children based on their psychological and mental status, which is very important. We think one of the areas that provides, safety for children is the ability for parents to not have any limitations to their parenting ability due to mental status. But again, that's only one factor, and to take that factor alone and then move towards reunification can put children at risk and be unsafe. So therefore, we look at that, and then we look at other factors, protective factors, such as if those parents or parent have a social network that they can rely on whenever they are stressed or whenever there is a difficult situation and they're no longer a service system available for them. What does the social network look like? That's a protective factor that often weighs in for children. The other is the basic and concrete needs for children. Not that poverty is an issue for neglect, but being able to meet the basic needs of a child or your children is a factor that if that doesn't exist, even though psychologically we're saying the mental status as well, then that factor too has to be weighed into it. So there are multiple set of factors. Those factors go before the court. The court often have given a set of stipulated actions that a parent must take. One may be to successfully complete a parenting class. And though the psych eval says the parent is okay, the parenting program may say, well, there's still a lot of areas that we see are deficient that this parent needs to work on before a reunification happens. And so that's how dynamic it can be. And so we're saying that if this legislation is only saying use the psychological eval from a clinical professional to make the decision, then everything else gets ignored and children then could possibly be at risk.
Thank you for that answer. Are you of the opinion that the process could be expedited a little bit better? And it's been a challenge because of factors like staffing and other kind of things that are getting in the way, or do you think it goes through in a timely manner?
Right. I mean, one of the areas we don't do well in the state of Connecticut compared to other states is timely permanency. We know that it's an area that we have to improve upon, that when children enter foster care, they shouldn't stay there one day longer than they need be. And the factors that we go through in order to get children back home when reunification is ready sometimes can be laborious. And we are in the process now through our practice evaluation to determine how do we improve the timeliness of kids going back home. We don't have a problem with kids being reunified. We have a problem in Connecticut. It's not a major problem, but it's enough for us to pay attention to and to take some corrective actions with children going home in a timely manner. So yes, there's some room for that.
Yeah, thank you. Thank you for that answer. And thank you, Madam Chair. Appreciate it.
You're welcome, Representative. Thank you so much. Are there any further questions? Seeing none, thank you, sir. We appreciate your time.
You're welcome. Thank you all.
Next, we'd like to call Matthew Lesser, Senator Lesser, and I know that I believe he is trying to get on now. Let's give him just a second to see if we can get him on the Zoom. No. Okay, we're going to recall Senator Lesser when we have him available right away. I'd like to please call Representative Poulos. just press that button on the microphone, representative. And if you would introduce yourself and the constituents you have with you, and we'll get right into the testimony. Just a reminder that the bell will ring after 3 minutes beginning now. Go ahead.
Okay, thank you, Madam Chairs, for having us here today. I'm here today with two lifelong residents of Connecticut. They both live in my district in Southington. And their names are Mr. Stephen Grenier and Mr. Robert Farler. And they're here to share their story about their adopted son, James, who they adopted out of foster care at age 11. And so without any further comment. Yeah.
Thank you, Representative. Hello there and welcome. If
There
you
we
could
go.
please state your name for the record and then go ahead with your testimony.
Yes, I'm Stephen Grenier. I'm here with Robert Farler, my husband, to voice our support for HB 5852. As Chris said, not just for ourselves, but on behalf of our son, James. To give you a little background on ourselves, our adoption journey began nearly 8 years ago, just after we were married. After exploring different types of adoption, including infant adoption and surrogacy, we determined that adopting a child from the foster care system in another state was best for our family. We were fortunate to meet a 7-year-old boy named James, who would later become our adoptive son. We met him in October 2018 in a bowling alley in Auburn, Massachusetts. Our son was born in Worcester, Mass. In February 2011, and at that point, he had been in the care of Mass DCF for about half his life. Fast forward to the present, James will be 12 next week. He's in the 6th grade, and we finalized his adoption on April 13th, 2022, after he was in our care for 1,153 days. James knows that he wants to attend college and will proudly say that he aspires to be a journalist, although he's unsure at this point if he wants to cover traditional news or sports. We want James to be able to follow his dreams after high school and not be burdened with excessive student loans when he begins his career. The difference between our situation and a family that has had a child since birth is we were over a decade behind in saving for James's college education. Currently, when a child is adopted by a Connecticut family from a different state's foster care system, that child will forfeit any tuition assistance from their home state and will not be eligible for tuition assistance from Connecticut. We feel that James should not be penalized for being adopted by a family that lives in another state than he was born in. James should be guaranteed the same opportunity to pursue a higher education as other children that are adopted in the same state that they are born in. During the adoption process, we had the opportunity to meet many children that were in the care of the Massachusetts DCF. These children are often the most vulnerable members of our society and have been placed in circumstances that they are struggling to understand and that are often not their fault. We strongly feel that these children should have the chance to be adopted by any family that is a good fit for them, regardless of where they reside. Also, adoptive parents should not have to decide between adopting a child from another state and providing that child with the opportunity to attend college. Thank you for your time and urge you to support HB 5852. Thank you.
Thank you so much for your testimony. Thank you for being a foster parent. Happy almost birthday to your son.
Yes,
I have children the same age. It's a great age,
it's a fun age for sure.
but be careful, it goes downhill after that. But-
It's already started, yes.
So if you don't mind, I have a couple of questions for you.
Yes,
And if you don't know the answer, that's fine, because we'll figure it out on our own as a committee. That's our job. But your son and his inability to get tuition assistance from Massachusetts is because of Massachusetts law, correct?
I do not know the exact answer to that. I believe Massachusetts does participate in some sort of tuition arrangement, but I am not 100% sure. I thought the holdup was on the Connecticut side of things.
Okay, because one of my questions is that Connecticut does provide tuition assistance for children adopted out of Connecticut in the Department of Children and Families in the foster care system, which is great. What they're looking to do is really provide a benefit for someone to help our children out of the system and into a long-term home. So I am not aware if Massachusetts has that. This bill, we have seen different iterations of this bill come through this committee for quite some time. The first bill basically said, if you are adopted and you live in the state of Connecticut, we're going to pay for your college tuition. And the way that it works here in the legislature is that we have something called a fiscal note, which says this is how much it's going to cost the state. The issue is that you don't know in advance how much it's going to cost. So it has to be for every single kid to put into our budget. And that turns out to be like millions and millions and millions of dollars, even though some kids might not go to college, some kids don't need the assistance, so on and so forth. So that's always kind of really been a holdup. The Department of Children and Families just has this wonderful program and it's very, very generous. I guess the question now is if it's Massachusetts law that you don't, because you've taken the child into another state, we cannot affect Massachusetts law. That's just not, it's not within our purview. But there now is this new iteration of the bill put forward by your fantastic representative that is about joining a compact that says, if you take our kid, we'll send them to school, but if we take your kid, we'll send them to school, and it's an agreement. So have you spoken to anyone in Massachusetts? I would assume that you're still in touch with Massachusetts DCF as you are a foster parent of one of their children. Is there still conversations between you and that entity?
No, there's not. We haven't had conversations with them since the adoption date last April.
Wow, I'm surprised.
Yeah, me too.
But okay. Okay, so I guess my question is this: knowing that the state has fiscal constraints, I know that they would love to be able to do this for everyone that they can, but sometimes it's just not in the cards simply because of the amount of money that it would require to do that. Do you? Might it be possible that you need help from your representative to contact Massachusetts to see if there are any programs that you would qualify in Massachusetts? And if that's the case, is that something you'd like your representative to do?
I can certainly reach out to the contacts I have. If that does not get anywhere, we could see where that goes for sure.
Surely.
I could start on my end.
Yeah, and please know that as chairwoman of this committee, I'm more than happy to help facilitate that. And then secondly, there was some talk around the original bill that along with Senator Kelly, we came up with what we really thought was a great idea. And that was for kids, not that were out of state, but were adopted before we had the original program. There were some families that wanted to be included. And we thought perhaps it would be worth it if we went outside those dates, but did not pay full cash tuition, but partial based on families' need. And after you fill out the FAFSA form, you get all of the federal aid that you can, and then perhaps there's a percentage of what's left. Is that something that if we were, and remember, no promises, this is a fact-finding, idea-digging mission. If we were to look at the possibility of that, would you find that helpful to have at least partial help rather than the full cash payment?
I think any assistance that could be provided to these families, these Connecticut residents, and for the benefit of these children to attend college would be helpful.
Excellent. And your child is currently turning 12.
He is.
So you are being proactive now. And if this takes a little while to work on, you understand that.
Absolutely.
Excellent. Great. Thank you very much. Those conclude my questions. Is there anyone else? Senator Mar, did you have any questions? No? Okay, great. Representative Kitt.
Not so much question as a comment. As adoptive mother myself, my child just started college this year, so I understand your concerns. So I would be interested in hearing some of these options that our chairwoman has brought up. Are there any other types of services that you would like to see for families who are adopting out of foster systems? My adoption was sort of a quasi foster private adoption. But speaking as someone who came strictly from the foster to adoption program.
We actually worked through a private adoption agency here in Connecticut, and they hooked us up with the Massachusetts Department of Children and Families. So it was a little hybrid too between private and through the state. In terms of any other services, I mean, not that I can think of. Everyone has been very helpful through the process of, bringing James down to Connecticut and making sure he fits in and he has what he needs to be supported, and that we as parents have what we need to be supported as well. So not in our situation, no, nothing I can think of.
Okay, thank you. I'm just, I would love to see a greater promotion of adoption, so.
Agreed.
Thank you very much. Are there any other questions? Okay, seeing none, thank you very much for your testimony, and I look forward to working with you in the near future.
Thank you so much.
Thank you, and thank you, Representative. Is Senator Lesser available?
He is.
Hello, Senator Lesser.
Hello, Madam Chair.
Please go ahead with your testimony. We're happy to see you here.
Thank you so much, Representative Linehan, Senator Marr, Senator Seminara, and Representative Dauphiné. And I'm very glad to be before the Children's Committee. And I want to lift up all the fine work that you do. This is an incredible committee, and talking about some important issues today. I'm just here to speak in support of proposed Senate Bill 480 this afternoon, and just talk about some more about the issue that you've been hearing from. I've heard from foster parents in my area that we need to do more to support them, and that we are not doing enough to make sure that the foster parent system works at its best capacity. And I would be glad to defer to subject matter experts, like Representative Kitt, who have lived this experience firsthand. The bill that you are hearing today, Senate Bill 480, seeks to do three things. One, it's to develop a strategy to reduce turnover on DCF frontline staff. I've heard that causes a certain amount of chaos and may lead to things falling between the cracks. Two, it seeks to make sure that DCF staff are adequately trained, especially able to benefit from bias training. And then third, it directs DCF to develop and disseminate a foster parents' bill of rights to make sure that for existing rights that have long existed, these are places where they could have intervener status, et cetera, that the parents know what their role is in the process, they understand the process, and they can adequately participate. And it's my hope that these three small tweaks would help strengthen the system, provide foster parents with the support that they're seeking, and make sure that we all have increased confidence in our foster parent system. And with that, I just want to thank the committee for its time and its flexibility on scheduling this morning and afternoon. I know it's been a little touch and go.
Thank you very much, Senator. I appreciate you. I have one question, really, because you were not in the room when I asked Deputy Commissioner Williams, but I guess my question is around bias training. Is there a particular bias that you're concerned about? Is it racial? Is it sexual orientation? Is it classist? I mean, or all of the above?
I think all of those would be important. I have heard specific concerns from parents that they feel that DCF staff are being directed to reach certain conclusions in investigations. I can't speak to that, but I think what I've heard from the parents that I've spoken to is they want to make sure that there's a comprehensive bias training, and we can certainly discuss the details of that. And I will go back and review the Deputy Commissioner's statement.
Great, thank you very much. And that answers my question. Are there any other questions from members of the committee? Let me check Zoom, sir, just a second. Seeing none, Senator, thank you very much. I appreciate your time, and you are a real fantastic advocate for your constituents. Thank you so much.
Thank you.
Okay, thank you. We'd like to call Jennifer Fell, please. Thank you so much. If you would turn on your microphone, and you have 3 minutes.
All right. Good morning, members of the committee, or I believe it's afternoon now, right? Thank you for hearing my testimony. My name is Jennifer Fell. I am a foster parent for 5 years in Connecticut. I have adopted 2 children. They're 3 and 8, and they are incredible. I've also been part of DCF's QPI core group to help focus what DCF is doing on building relationships and providing excellent parenting to kids every day. In reference to Senate Bill 480, I, of course, support a foster parents bill of right, and I support the bias training. And just to shed a little light on some of the topics, there was a study done in Long Island where when they were considering removing kids from their homes of origin, when they removed the neighborhood information, the demographic information on race, income, and those kinds of things, what they saw with these blind removals, that kids were much more likely to stay in their homes. The disparity of removals of children of color versus white children decreased. And so they saw that bias doing blind removals actually helped improve that. So, but that's not what I want to talk about. What I'd really like to talk about is staff turnover. So while staff retention in statistics in DCF are admirable, they have one of the best turnover rates in the country. I want to talk about as oversight of this as it relates to a child's individual case. So when you change over social workers, it delays permanency. So this impacts, there's more children in foster care. There's additional trauma from the longevity of being in foster care, even in the best homes. I believe I have one of them. It sucks. It's terrible to not know where home is going to be if someone's going to make a decision this week, next week, or months later. It also, the longer you're in care, it decreases the likelihood of reunification, and it also decreases the likelihood of adoption. Okay, and this is really significant. Now, workers get changed when they leave the job. Great for them. Promotions change. That's wonderful. But they also, when they graduate from their training, they make it switch. When their caseloads are shuffled, there's many reasons why this turnover impacts the individual case. We're all familiar with the game of telephone. We whisper a message this way, and by the time it got around the room, it might be a very different message. And when we're talking about caring for the case and the complexities of a child's trauma, relationships with biological parents, and we're passing it caseworker to caseworker, things get lost. And it is not due to a deficiency in the worker. Right. This is just the nature of how communication goes. So I strongly support SB 480. I think that I'd like to ask that we take measures to be put in place to track staff turnover as it relates to the number of caseworkers that oversee a child's case. Bringing in data and looking at this will let DCF do the job that they want to do so desperately, but it will help them to make smart decisions on how do we manage caseloads? How do we shuffle and work? Thank you very much.
Thank you for your testimony. Are there any questions? Madam Co-Chair.
Thank you very much. Hi, and welcome to the committee. I think that, we've been talking on and off now for a while, but I think this is the first time you're able to come in.
Yeah.
So happy to see you here. And I believe you're also Senator Lesser's constituent, correct?
No, I am.
Oh, okay.
No. Well, now I'm blanking on my senator.
That's all right. We'll
Because
figure
I'm
it out.
nervous.
Don't be nervous. Don't be nervous. So, we've had some kind of back and forth about like what's the best way to move forward to get where you want. But I have to admit, I'm a little confused because this bill is looking for changes that are undefined. And you're sitting here asking for data. So I just want to clarify for the record so that we know how to move forward, right? Is it more of a study you want to see if or how often this is happening?
I think that we should consider study and reporting out. I don't think I know that we can't make blind changes without seeing the nuances that are happening within the department. I know that they have done some permanency studies and they know that changing workers impacts that, but I think we need to be looking at it and reporting out and seeing why we're changing the caseworkers over the cases. So I think that we need to call data as part of the bill as the first layer before we just make changes or we make commitments to legislation. Because
Okay.
we'd be doing it blindly without really knowing what we're actually changing in the department.
I have to say, I am absolutely impressed with you and the fact that you're here saying, first, let's know more. I think that I just think that that says a lot about who you are, and I thank you very much for that. I believe that DCF does in fact track that information. Has it been that you've never had access to that information?
So they may track it. I don't know. It's not been publicly available to date. And I don't know that it's been consistently tracked. I've been in meetings where they said, we know we have tracked it. So I'd like to see it more formally and publicly shared.
Okay, and a lot of times, some of the changes that we make don't have to be legislated. They can be done by conversations, handshakes, and moving forward. Have you had the opportunity to try that yet or no?
Yes, many times. And DCF has been incredibly gracious in giving me a seat at the table, having conversations and letting me be part of some of their task forces.
Oh, great. Okay. Excellent. Thank you very much for your testimony. And I think that you've given us a lot to think about. And I am sure your senator will get in touch with you.
Senator Fonfara.
Got it. Fantastic. Thank you. That's all I have, Madam Chair.
Thank you. Other Representative Lanu.
Thank you, Madam Chair. Good afternoon, Ms. Fell. How are you?
I'm good. Thank you.
And again, I want to echo what Chair Lenahan had said. Thank you so much for coming before us and testifying and shedding some light on this issue. I just have a couple of quick questions on something you mentioned.
Sure.
Correct me if I'm wrong, but did you say that there's a correlation between change in caseworkers or turnover in caseworkers and the less likelihood for adoption of the child? Did I hear
So the correlation is changing. So this is an extrapolation, right? So turnover in caseworkers delays permanency, but there are national statistics that the longer children are in care, the less likely they are to be reunified and also less likely to be adopted. So the longer they are to, stay in care until they age out, which is a travesty, right? We remove them from their home and then we say, also, you have nowhere to go.
So the older the child becomes, the less likelihood there is for adoption.
Yeah, unfortunately, yeah. Yeah, and I want to shape it up and pretty that, yes.
Sure, I understand. Again, I'm trying to just connect the dots
Sure. Yeah.
with turnover and or change in caseworkers. How does that relate to the adoption piece of this? I'm sorry, I'm just trying to understand it.
Sure. So there's a delay in process. If I may, I can share my personal story.
Yes, please.
So my daughter came into care at about 3.5. She had a caseworker. I think they switched a caseworker that first year, right? So then she started a relationship with a new caseworker. She bounced a couple of foster care homes. Then she landed with me. We were tracking towards reunification with family. And then they decided we're going to move towards adoption. Then she got a new caseworker, supportive of adoption. That caseworker graduated and got new supervisors. The supervisors were fatherhood advocates. So dad, freshly out of jail, they said, let's give him more time. So then we got a new social worker and their team said, let's go towards reunification or let's go towards adoption. And then they switched back to the old supervisor, right? So we had a series of social workers and supervisors, and then they went back towards reunification, or they went back towards, reunification. And eventually 4 years after most of my daughter's life had then been spent in foster care, I was able to adopt her last May. So the intentions were good, but the bouncing back and forth in different perceptions. And then also details. So I became the historian, right? I became the historian while they're working towards reunification. I'm saying, did you know that at 4 years old, she didn't recognize her dad when you first had meetings, when you first started to introduce her, she didn't know who her dad was. So reunification was just unification when there was no reunion there. And there were lots of different things that it becomes reliant on people outside of DCF to help share, but at DCF's setting the cadence and moving through the process.
Do you think do you think the only issue here is turnover or change in caseworkers, or do you think there's too much flexibility and not enough stringent criteria on reunification versus adoption versus some of these other options?
Like, how much time do we have? No, I think there's a lot of different things. Yes, I do think that we don't make decisions maybe as quickly enough as we should, but that's a separate issue. And I think that is more of that we need to decipher and look through. I think when we look at simply managing caseworker turnover, and we look at and I say simply knowing it's very complex, right? I've overseen large organizations. I know what that looks like, but I think when we look at just that, we're really looking at the data, and we're looking at things that it's not a level of judgment. We just know we shouldn't switch up the caseworker if we could avoid it, because we need to keep this kid on track, right? And so there's other ways to look at managing your staffing around that. So I pick this as my pet issue because I know it would make a huge impact, but it's also not, we're not pointing fingers. We're not saying anyone's doing it wrong. We're saying, let's get better, so that's where I think we can make a big impact. So I think there's a lot of other things, but in particular, I think that would make a huge outcome.
Well, thank you very much for your time and those answers. I appreciate your insight, and congratulations on becoming a mom.
Thank
And
you.
she's a very fortunate young lady. So,
Thank you.
thank you.
you.
Thank you, Madam Chair.
Thank you. First off, I just want to say thank you for your testimony, and I'm so sorry that it was as difficult as it was, and at the same time appreciate the fact that you were the recorder and historian for your child.
Thank you.
So are there any other comments or questions? Anything online? Okay, thank you so much.
What? Wait, I'm so sorry.
No. Okay, we're good. Thank you so
Awesome.
much.
Thank you.
Crystal Laffin? Is Crystal online?
I'm here. Can you
Okay.
hear me?
Yes, thank you.
Thank you very much, Madam Chairs and members of the committee. My name is Crystal Laffin of Middletown. I'm a foster parent, and I've adopted a beautiful son from foster care, and he is the absolute light of my life. I'm here to support, put my voice to support PSB 480 and ask you to join me in supporting it as well. And I'd like to start by giving you a list of names. Gabriel Fernandez, California, 2013. Jordan Bellevue, Florida, 2018. Dylan Groves, Ohio, 2019. Harmony Montgomery, New Hampshire, Massachusetts, 2019. Oakley Carlson, Washington, 2021. Judah Morgan, Indiana, 2022. Quentin Simon, Georgia, 2022. And now Veronica Hernandez de Jesus, Connecticut, 2022. These are a handful of names of children who were killed by their biological parents after being reunified. After hearing so many of these tragic cases, I decided to take action. In December 2021, I helped organize a group of Connecticut foster parents with the intent of seeking reform of the foster care system, as well as expanding the rights for us foster parents to help us better advocate for the children in our care. You see, the federal government passed the Families First Act in 2018, setting the reunification rate goal at 70% when it has previously been 40% in Connecticut. While family preservation is always the primary goal of foster care and something that all foster parents support, it's not always safe, and it's not always in the child's best interest. Unfortunately, reducing children's lives to quotas is also not in their best interest. Children's safety should always be the first priority. In December 2021, I began reaching out to members of this committee, my representatives, and to other agencies such as the Center of Children's Advocacy and the Office of the Child Advocate, warning that our concerns that these new initiatives have a high potential for fatal results. And they did this past summer when 4-year-old Veronica was taken from us. We're not here to be adversaries to the state agencies involved, but rather to be a partner in protection of children. Myself and others have been sharing our concerns and suggestions with Senator Lesser to improve the foster care system for everyone involved. Us foster parents are the ones on the front lines each and every day. We see our children, we see what our children go through, and we understand the system very well. Yet we rarely, if ever, are consulted in our children's cases, nor in the policies governing their precious lives. Please listen to us and work with us to help improve the foster care system and ensure that our state's most vulnerable children's rights and safety are the biggest priority. By supporting this bill, you are supporting the ability for foster parents to better advocate for foster children and for caseworkers to get the support and training they need to best protect the children, and hopefully to reduce worker turnover in the long run. Please be a partner with us and help us protect our children. Please support this bill. Thank you very much for your time and consideration.
Thank you for your testimony. Are there any questions? Madam Co-Chair.
Thank you very much, Madam Co-Chair. Hello there, Crystal, and thank you so much for coming and giving your testimony today. I absolutely appreciate your insight. And the reading of those children's names is heartbreaking, to say the very least. But we are faced with this bill that right now doesn't give a lot of direction. This is called the subject matter public hearing. And so that's what we're trying to figure out, right? How do we want to draft this bill? And so you're asking for support, and I hear that you, and please correct me if I'm wrong, but you believe that the voices of the foster parents who are recognizing the dangers are not being heard appropriately, and you would like to have a greater voice. Is that correct?
Yes, that's correct, Madam Chair.
Great. And so, I hate to put this back on you, but you're the boots on the ground. So how do you see that happening?
We've been discussing it a lot in our group. One of the ways that I think could really help is if we are able to, right now, we are allowed to file to intervene in the case. However, that's up to the judge, and it very, very rarely gets to be able to be granted. If we had a situation where we could be automatically considered interveners after 12 months, which we feel is a fair and right time frame, considering that the permanency of the child is supposed to be set at 15 months. They should be achieving permanency at 15 months according to what's written. So 12 or 15 months, I could understand either. If we are considered automatic interveners, that would allow us to be able to grant us a voice in the court system and be heard. We don't have the right to be heard right now. A judge may say, if you show up to court, they may call on you, but that doesn't always happen. And as I understand it, very rarely happens. So we would just like the right for our voice to be considered in the case, so we can advocate.
Okay, and you used the term intervener for the benefit of the committee. Can you define intervener for us?
An intervener is, as I recall, and I don't have like the legal term, I'm just going to go off my head. When you come into the case, because as foster parents, we are not party to the case. The case is with the biological family. When you intervene, you become a party to the case, basically. So you are coming in and adding your voice to it. You're now part of the case as well.
Okay, thank you. And so I want to choose my words carefully because I really don't want to offend. So if I do, I apologize in advance. I think whenever we're looking at these bills, I always put myself in that spot and try to see it from the point of view, for right now, would be of a foster parent. And I think for myself that I would be so emotionally invested that perhaps what I'm seeing is not necessarily unbiased. So if there were some sort of ability to petition the court as the foster parent to be considered, being that your boots on the ground, do you have any understanding of what possible guardrails could be put in to ensure that this is coming from a place of reality rather than just of total emotion?
That is a fantastic question, and it's definitely something that we discuss, because you don't want the pendulum to swing the other way. And we as foster parents do have the responsibility to be looking at the case as a whole, and to be looking at our own implicit bias when we're talking about implicit bias, ourselves, and looking at the case. So I don't know of any guardrails. I agree with you, though. I think that we want to make sure that there are elements in place to prevent that from happening. But I'm also, much like in I guess the bill 479, where we're not asking to be the sole judgment, like our only voice, much like, where we don't want the psychologist's voice to be the only voice making that determination. I don't think that our voices should be the sole determination. I just think that they should be a part of the holistic approach that we're looking at. And I think we should be a contributing factor towards the evidence. I don't think that we should be the sole determination. That's not fair to anyone.
Once again, I would like the same thing that I said to Ms. Fell that was here. I want to thank you for your understanding of the system and recognize that, as a foster parent, there may be a little bit you're coming at this from one direction, but you are considering all others. So I do appreciate you. So I just want to make sure before we move forward that what you're saying is that there's no official path for your thoughts to be considered. And one of the things that you would like to see happen is that in statute, an official path to have you or the foster parents' thoughts be considered by the judge, that there is the right to do that rather than having to fight to get that done. Am I correct?
Yes, exactly.
Okay. See, this is the clarification is fantastic. So my co-chair and I and the rest of the committee members will actually think about this and see if there is a path, some way forward to do that, because I think that what you're saying is true. And it's almost like, in my mind, like a victim impact statement at sentencing, right? There is always the ability to do that. So this would almost be like a foster family impact statement or something similar. And so now you've got my brain working. I just want to caution that this is no guarantee that we can do this. A lot of things of what we talk about, they're subjected to different statutes and federal laws that may not work together, but you absolutely have my word that I will look into the ability to do that. And whether or not we can legislate something, I don't know, but we will figure that out on behalf of not only you, but also of Senator Lesser, who has been a really great advocate for you and your thoughts.
Thank you, Madam Chair.
Thank you so much. Back to you, Madam Chair.
Thank you. Are there any other questions, comments? Okay, thank you very much, Ms. Laffin. We appreciate you.
And we're back to me. And the next person we have is Olivia Rinks, followed by Morgan Alicia. Do we have Ms. Rinks? Okay, she is unfortunately not here. If she does arrive, we will absolutely call her at the end. Morgan Alicia, you're on. Welcome to the Committee on Children.
Morning, can you hear me okay?
Yes, we can. Thank you so much.
Okay, great. I just want to thank everybody for taking the time to hear us today. I'm here in support of the Bill 480. My name is Morgan Alicia, and I'm from Cheshire, Connecticut. I've submitted written testimony about my own experience with Connecticut's foster care system, but I also want to speak briefly on this issue as well. As foster parents, we are asked to love, care for, and be responsible for children as if they are our own. These children that come into our homes have all been traumatized in one form or another. Regardless of the extensive training we go through to not only become but remain licensed foster parents, nothing can truly prepare you for the extensive challenges and difficulties that come with fostering. However, these challenges are currently compounded by the Department of Children and Families. This department is supposed to be protecting children, and yet their ever-changing policies, lackluster procedures, and in many cases, blatant disregard for the child's well-being has made our roles as foster parents near impossible. We cannot protect these vulnerable children when the system is as broken as it is now. Children are being reunified without proper procedures in places, all in an effort to meet a quota to gain federal funding. DCF is skipping over critical elements such as thorough reunification assessments, psychological evaluation, and ensuring that there have been significant changes in those who have caused their children to come into care. Even in cases where these elements are satisfied, ultimately, if the results do not align with DCF's motives, then they are completely ignored. Too many children are being thrown back into unsafe homes, all in an effort to reach DCF's goal, which is reunification. However, their goal should be permanency for these children. Where is this child going to have safety and stability? Who is going to ensure their medical, emotional, and physical well-being? Where is this child going to finally be able to call home? The answer may be reunification. Plenty of biological families actually do complete their program successfully, but when that doesn't happen, other alternatives need to be explored, such as kinship placement, guardianship, or adoption. DCF needs serious reform and to look at cases individually rather than just checking off boxes on a list. There is not a one-size-fits-all approach when dealing with foster care. Foster parents deserve to not only have their opinions heard, but valued. In creating the Bill of Rights, we aim to do just that. Passing this bill could help ease the fear of retaliation from the department when we disagree with their approach. It would ensure that workers and their superiors are held accountable for the decisions that they make. And finally, we believe this bill would bring some balance to the system overall. As others have and will indicate, this bill is not a pushback against reunification. In fact, we believe by having foster parents in a much more active role, reunification may become more plausible as the foster and biological families work together. And in the event that reunification is still not in the best interest of the child, the families would know who their children are with and may even be able to remain in the child's life so long it was safe to do so. We want to be able to weigh in on the very major decisions for the children we are entrusted to care for, the children we come to know and love as our own, the children who look to us to help protect them. Foster parents experience this process from all angles, and we deserve to be treated as an equal part of the system rather than just glorified babysitters. We need to do better for these kids.
Thank you so much for being here. You're always so great as an advocate, and thank you very much for being such a great foster parent. I do have some questions. Were you able to listen to the testimony of the others before you?
Yes, I was.
Okay, great. And so a lot of this is kind of the main theme that we're hearing is that foster parents feel that they're not having enough of a say within not only the adoption process, but also the reunification process. And so would that kind of easily characterize the same things that you're saying?
Yes, I listened to the deputy commissioner, and he listed off all of these different avenues that we technically do have. But as someone who went through all those channels, all those avenues, and ultimately had to hire my own attorney and just really push back. I was told at each one of those turns that they couldn't help. I did have my own worker and she was supportive, but she ultimately, she didn't have any way to help me. I did contact the ombudsman. I believe even you and I, Liz, we've met a couple times on this, and, the roadblocks were insane. And, luckily we were able to make some progress, but we're still not where we should be.
You know, something that it just occurred to me that I hadn't asked you before, and now it's like right in front of me. Have you been invited to sit on any boards or in any working groups alongside DCF to be heard as a foster parent to let them know of the problems that you faced?
No, and to be quite frank, I wouldn't expect them to. Unfortunately, I don't think I made many friends in DCF just because, you know, I was so very much against what they were doing. And if you read through my written testimony, you can just see how many different ways, you know, they didn't do what they were supposed to. So I don't know if I would actually be welcome.
So, you became a foster parent in 2017, correct?
That's correct.
And you gave up your license.
I did. Unfortunately, after everything had gone through, you know, with my son, technically I'm only his legal guardian. I just unfortunately couldn't be part of the system in that way anymore. I do still try to, you know, contribute in things like this with the reform. You know, we have charities that we put together, but I just could not subject myself and my family to DCF's practices anymore.
You know, when we've spoken before, you know, I've always brought up the fact that I just feel like it's such an emotionally charged environment. But since you have given up your license and you've stepped back, it's almost like that emotion has taken a back seat to advocacy for real change, correct?
Yes. Now that I'm not actively, you know, a foster parent, my son is not actively in foster care. I do feel like I can speak freely about the things that I've experienced and that other families that are still experiencing it. I have close friends that wanted to be here today or submit written testimony, and they're just frankly afraid of the backlash.
So if you could always let them know that they can, well, it wouldn't be official testimony. They can absolutely contact the chairs of this committee and remain anonymous. But I think that you guys have all given us some really great things to think about. Like I said earlier, is the problem with subject matter public hearings is there's not legislation written to directly attack the issues. It's like we're all here trying to hear more of what the issues are. Part of my concern is that this issue is not something where I can point to A, B, C, and D that's going to make an actionable difference. And then like let's march in the streets to get it done. You know, when we had Ms. Fell, who was testifying, she had said that she thought it was important to get some data first, you know, and so I'm thinking to myself, well, maybe she's right. And it's the data that we're looking for before we can make those changes. And I don't want, if that happens, I don't want someone like you who's just been so involved and fantastic. I don't want you to think that that is lack of action. I think that's going to be important that whatever action we take is really methodical. And takes everything into account. So if that is the process and the direction that we decide to go, would you be interested in helping this committee further that by using your expertise as a former foster parent and now the guardian of a former foster child?
Absolutely, because I think this bill is just the beginning. I think there's still a lot of other things that need reform and tweaking and, you know, procedures to be put in place and then actually followed. I would be honored to be part of that.
No, I think the honor would actually be all ours, but thank you very much. I will be in touch with you about that. Are there any other questions from committee members? Oh, great. Thank you. Senator Seminara.
Thank you, Madam Chair, and thank you so much for your testimony, Morgan. I just had a quick question for you. During your testimony, you said that there was retaliation from Department of Children and Families, and I'm just hoping that you might be able to, were you a person who felt that you were retaliated against? And if so, can you elaborate a little bit more on what exactly that was?
Yes, absolutely. Our case was kind of complicated, if I didn't go into the whole thing just because it's very long, which is why I have my written testimony, but our case had started out, with one direction. Obviously, they started with reunification. We moved through the process, all these different assessments were saying that reunification was not viable. We made it all the way to TPR, and just because of a clerical error on DCF's part, it was withdrawn as to one of the parents. And literally overnight, all of the things that they wanted the biological families to do and to achieve, literally overnight, they no longer mattered. And when I would point things like that out, they would shut me down. I was constantly in fear that they were going to remove my child, who at that point, at the failed TPR, he was over 2.5. I had him since 17 days. And then, as we just kept moving through, the communication would basically stop. There was a point where I was allowed to bring my son to visits, and that was good for him because it's a little less jarring than being ripped out of, your mother's arms and put into a sterile room. But they didn't allow me to do that anymore. I wasn't a part of, the planning. They were constantly trying to do new reunification assessments, and they just didn't take anything that I was saying. I would be documenting, the way my son was responding, nightmares. His therapist would be supporting it, and DCF just completely ignored it.
Okay, thank you so very much. And thank you for your service in helping children. It's a very commendable thing to do. And we very much appreciate all your efforts and your testimony to continue to try and improve this situation.
Thank you.
Thank you very much, Senator. Are there any other questions from members of the committee? Seeing none in person or on Zoom, thank you very much, and I will be in touch shortly.
Thank you.
Thank you. Next, we have Holly Gardner, followed by Becky Carlson. Ms. Gardner, are you with us today?
I am. Thank you.
Thank you. Please go ahead.
Okay. Good morning, Senators, Madam Chair, representatives, and distinguished members of the panel. My name is Holly, and my family has been a licensed foster family for almost 2 years now. I am here to support PSB 480. A few weeks after we received our license, we were placed with a baby girl who was born to troubled parents. And from the outset, we were just so in love with her. We viewed her as family. And by extension, our hearts ached for her birth parents. And we have tried to be as supportive as possible in their quest for recovery. Our experience with DCF has been a roller coaster. Speaking specifically to Bill 480, the turnover of caseworkers has directly affected our case. It does seem that the experience is really dependent on the competency of your caseworker. We initially had a fantastic caseworker who kept us up to date with information pertaining to our foster daughter's case. However, we sadly were switched to another caseworker. And though she's very friendly and well-intentioned, the lack of communication has been detrimental. We often were last to know about meetings, case review meetings, changes to visitation, and on more than one occasion, we've received messages asking us where we were for meetings that we were never informed of at all. I guess to kind of illustrate how intense that could be, in one of the meetings, we were randomly told that she would be being reunified with a distant relative. It was the birth father's stepmother, and she was no longer married to his father. And because of the immediate and without any warning to this information, my husband and I took it upon ourselves to we had to hire a private investigator, essentially, who found out that this person that they were preparing to send our foster daughter to had several criminal issues, several legal issues, and they were married to somebody who was incarcerated in federal prison for cartel charges. We had to do that digging ourselves. Because DCF was literally telling us to prepare our biological children to say goodbye to our foster daughter. It was a situation that kind of has echoed the sentiment that DCF really prioritizes reunification with biological family members. And without proactively vetting these people and incurring the cost of the investigator, our foster daughter would have been ripped from her stable home, her foster brothers, the only people that she's known as mama and daddy. Senator Lesser spoke of the feeling that foster parents see caseworkers sort of leading cases to certain conclusions, regardless of the safety of the children. And that's been our experience. I've never met a fellow foster family who felt that DCF fully supported the foster family. It seems that they do prioritize the parents, biological parents' rights. And of course, like reunification, when possible, is the goal. However, I have seen circumstances both with our case and with cases from others where it seems like the safety is compromised in the name of getting those financial incentives for reunifying children with biological relatives or parents. So all this to say,
that is 3 minutes. If you could summarize, please.
Sure, yes. All this to say, I do support Bill 480. I think a development of a foster parents' Bill of Rights, giving us more of a voice in the children's permanency plan, would help improve the overall safety of children.
Thank you very much for your testimony. I just sit here and I listen and I think to myself, like, what an emotional roller coaster. And so I'm sorry if I missed this. Are you still a foster parent to this child, or has there been reunification?
We are currently her foster parents. Recently, we did have TPR approved. I am a little nervous about speaking here today, but currently we are waiting for them to submit paperwork so that we may move forward with adopting our daughter.
Well, I'm not going to jinx it. So I'll just shh. But that brings me to the question then. So this experience that felt haphazard, you weren't heard, you hired this private investigator, but ultimately there seems to be a decision made that perhaps that reunification was not in the child's best interest, right?
Yes. And after we found out about the plan to reunify this child with the relative, despite talking to DCF and trying to get more information, we met several roadblocks and withholding of information. So that is why we took it upon ourselves to hire the private investigator, because it just seemed like they were just going to come and take her.
And so are you part of a foster parents group or anything like that, where you kind of all talk about what's going on?
I just recently joined this group probably 2 months ago, that Crystal and everyone has created.
Okay, because I just asked because I don't know if that's a normal course of action where DCF actually can share that information. I would imagine that would be confidential information due to privacy laws. So I'm just trying to ascertain as to whether or not normally foster parents are given that information, and in your case you weren't, or are they bound by privacy laws where they can't give that information? I don't mean to put you on the spot, but do you know that answer?
So I do know that we're supposed to be told, like, oh, they're going to be like, you're supposed to be given warning. I do know that in our trainings, they said, oh, if we're going to be taking your children, or reuniting the children, we will be giving you like a certain amount of time with warning just to help prepare the family. That was not done in our case. I understand that perhaps they can't share the information that the person has criminal history, but we were given no heads up, no preparation. And after we found out the information, there was no indication that they were vetting this person. It pretty much was just pack up her things, prepare your family for this.
And ultimately, then the child did go there and then came back, or didn't go there at all?
We took the risk of submitting the information that we found from the PI to the supervisor for the caseworker, and they took it from there.
And so the child was never actually removed from your home and given to this other family?
Correct.
Okay. And so I don't mean to put words in your mouth. I just want to kind of get it to be very clear. So your thought is, well, what if we hadn't done that? Right?
Yes.
Yeah.
Yes.
And what's really tough is that with privacy laws, they probably can't tell you if they did that or not, if they would have gotten to that. So I get where there's that disconnect. And then so we're going to have to, as a committee, really research, you know, if those roadblocks are because of privacy laws and things like that. But you've really given us something to think about, and I appreciate your time and your testimony.
Yes.
And
Oh,
it's
sorry.
really adding good layers.
Okay, I would advocate that. I think that if we were able to be more involved in the planning for their permanency, I understand privacy. You can't tell the foster parents that, oh, this person has legal issue or legal recourse. But even if it was just, okay, they're not going to be an option, that's the end of the information, that would be helpful.
So
I
is
think
this
just giving
talking
us-
about, are you talking about like protection for the child's emotional well-being as well?
Yes. As she has gotten older, she is more aware of like the circumstances surrounding her situation. At the time she was very young. So in that particular situation, it wasn't as much of a protection for her well-being. But at this point, if she were a toddler and we were preparing to send her somewhere, and it's like, I'm trying to find like the right clear words. Had she been more cognizant of like what was going on, I could see how that would be incredibly traumatic, expecting to be taken. Because we had about 3 weeks where we were thinking, oh my gosh, like they're going to come get her. And then finding out they are not. You know, it was a traumatic experience. It was very stressful. So I guess maybe if they knew for certain, like, yes, this person has already been vetted, we will be taking her and placing her with this relative, that makes sense. But they presented it as fact that, oh, we will be taking her and placing her, when in fact they did not have the full picture of who this potential relative could be.
So, and forgive me because I do think out loud during these public hearings, just because it's up to my co-chair and I to start putting together language. So we kind of really try to get as much information as we can here. So, the fact that that you believe that there wasn't the due diligence may or may not be true, because you can't know those things due to privacy laws. But there was still, regardless of whether that was there or not, the concern is that it wasn't effectively communicated to you where they are in the process regarding that. They're just saying, hey, it might happen, but it might happen, but we still have to do this, this, and this. So it could be that DCF was trying to do the right thing and not spring it on you, when in fact, the way they went about it and might be their current protocols is not actually helpful from a foster parent or foster child perspective.
I would agree with that. I would say, because it was presented as this is happening. Like that was our experience. And it could just be that the communication that day was poorly delivered, but it was presented to us as, we are placing her with another family member. Prepare your other children emotionally for this. Yes. And that's fine. But yes, so that's how that was delivered to us.
Don't worry, I have a husband too.
Yes.
Okay, so you've given me some really, I do it all the time. You've given me some really, really good information. And as a committee, we will certainly discuss that and kind of see what we can come up with. As we have said to previous people here who have been testifying, this is one of those things that it's not something that we have a list of things that we know can be done that can put directly into law. So, and I think this is coming from what you're saying, is we want to caution you, this may not happen right away, but that the work is absolutely starting. And your testimony has been extremely helpful in that. And I very much appreciate you. Are there any questions from other members? Representative Wiehlander.
Thank you, Madam Chair. And thank you, Ms. Gardner, for being here today. I had 2 questions, if you're able to just answer these. About how long ago did this process happen, and the roadblocks that you hit?
This was about a year ago,
Okay.
almost exactly a year ago.
Okay, great. Thank you. And are you able to recall off the top of your head about how many different caseworkers you worked with during this?
Thus far, I believe we've had 3.
Okay. All right. Thank you so much. I appreciate your time and sharing your story with us.
Thank you.
Thank you, Madam Chair.
Okay, sorry, I apologize. I'm back with you, but my co-chair and I are already talking about things. So see what you've stirred up. You've done a really great job, all of you. So thank you. Are there any other questions from members of the committee? Seeing none in person or on Zoom, thank you very much, Ms. Gardner. We appreciate your time.
Thank you.
Thank you. And then next up, we have Ms. Becky Carlson. Hello, Ms. Carlson. How are you?
Hello, I'm great. My name is Becky Carlson, and I am a citizen of Groton, Connecticut. I'm currently a college coach at Quinnipiac University, a foster parent, and a co-trainer for DCF foster licensing training. It's been almost 4 years since we brought our first foster daughter home at birth, and both her and her biological sister have not yet achieved permanency for reasons. We are hoping your support of PSB 480 can help to solve or alleviate some of the children languishing in foster care. Today, I represent almost 100 foster parents across the state who have mobilized privately out of fear of retaliation in their open cases. Thank you to Representative Lesser for sponsoring this bill and to the committee and distinguished members of the panel for hearing us today. The COVID-19 shutdown has had a profound impact on foster care, causing a backlog in cases, a high number of appeals, and overworked support workers. Overloaded workers, coupled with the voracious swiftness in which the foster system is attempting to satiate federal legislation via the Family First Act, has massive repercussions. This state-based goal to meet quotas by returning children to homes where the birth family is incapable or unwilling to create safe environments is a clear message that decision makers believe it is more profitable and less burdensome to prioritize the rights of birth families over the safety and well-being of our children. We are rapidly approaching a desperate phase in foster care, with our homes being asked to be revolving doors and treated as transactional partners. Required visitations for children with poor or limited oversight, where biological families are permitted to behave erratically, breach protocol, ignore safety plans, miss visit dates while demanding the schedules of the children be disrupted in favor of their own timelines. Worker exhaustion leads to policies inconsistently applied across the state, birthing miscommunication, lost documentation, failure to report or transfer critical information from one team member to another. Our medically complex foster daughter was drug exposed at birth and suffered greatly in utero. Born into a family with a history of addictions, domestic violence, and mental health issues. For the next 14 months of her life, she would be required to attend supervised visits with an unpredictable bio parent who verbally assaulted support workers and even removed our daughter's leg braces against medical protocol because her disability was visually displeasing to him. While she had an attorney, she was too young to use her voice. And as her caregivers, we had no one to listen. She is almost 4 and her sister is almost 3 and still waiting. The body of the foster system is made up of the judicial system as the head. DCF is the neck, the children are the heart. Biological families who commit to making change are the feet that hit the ground running and work to get their children home. The biological families who are the hands of the foster system can use them to manipulate the system, while foster parents are the spine. The body cannot live and survive without the spine. We ask that you support those families hitting the ground running, but start holding those accountable who use their hands and regard children as property rather than people. I want to be clear, myself nor the group are anti-reunification. Returning children to healthy, stable, and willing homes was, is, and will always be the goal. We're not uncaring or unwilling to do the work. We want to protect and collaborate. Foster children deserve supported workers who, rather than check boxes to meet quotas, are equipped, energized, valued, and empowered with the ability to support families of all kinds, without the unrelenting pressure to live up to the state's upward trending mantra of biological is always better. We believe safe, healthy, and happy is the only better. We are a passionate group that asks that you consider PS Bill 480 to help us be collaborative in a way that makes every one of our invisible children and their rights seen. I'm happy to take any questions or add context to the bill on behalf of our group, especially the bias training portion that Representative Linehan had questions on in the beginning. Thank you.
Thank you very much for your passionate testimony. And I appreciate you coming forward on behalf of others. I just want to comment, did you submit written testimony as well?
I did not.
Okay, yeah, because I'm looking through it. I'm furiously looking through it, trying to find you. Can you submit that, everything you just said? I feel like that there's so much in there that I want to unpack, and I'm going to have to come back and do that after fully reading it and digesting it.
Sure.
I think that's when we will kind of formulate more questions, because there's just a lot to unpack. Is that something you can do for us?
I sure can. Representative Linehan, if I can, I was dying to answer the questions. I was along with Crystal, who are the ones that met with Senator Lesser to be able to clarify. You asked many questions throughout this about clarifying bias training. Would I be able to give you some clarification on that?
Absolutely, please, and thank you.
Thank you. What we need from the powerful people in this room is to understand how the Foster Bill of Rights is tied to the other two components of support workers, as well as the bias training. You will have to forgive us. We are a passionate group, and it's possible that bias in the language was not clear, but I want to help. So our foster parents experience a fair amount of bias in the process, but I want to clarify that outside of the racial bias components and the LGBTQ, which DCF is clearly tackling, based on Deputy Commissioner's testimony, the inclusion of the word bias is based on a recognition of a behavioral bias. It's a disconnect for our exhausted workers, and it labels the behaviors of foster homes. You heard Deputy Commissioner Williams talk about the wonderful contributions that foster homes make to the system. He's absolutely correct. You heard from foster parents. That also means that you have passionate, committed families that feel muted, unheard, and when it comes to the safety of children in their homes. So when our foster parents express those needs to their teams or advocate for their children, which we've been taught to do in training, there becomes two pathways of image that are being carved out for the foster parent or the foster family. Image number one is you're a strong advocate who is emotionally connected and needs support and needs to develop further trust in that relationship with your worker. The second image is that you are an emotional, unorganized threat to the system and a hindrance to reunification. Once that behavioral bias takes over, it has a ripple effect on the process moving forward and how that home is regarded and what could be years of that child's legal proceeding. It's a permanent label. This is the behavioral bias we're trying to eradicate within well-meaning workers and teams and help make those distinctions so they can triage them in a meaningful way. We are trained and licensed to be parents to these children when their birth families can achieve reunification. The natural instinct to protect by our foster family should not be considered a weakness or brand as a home as a problem or obstacles to the goals of the department. Representative Linehan, you asked the question, what is it that we want, right? Everyone's kind of like, guys, we're kind of really honing on what we want. We've never been asked. We've never been to the table. We're not looking to craft a Bill of Rights in isolation. We need help, and we're not trying to reinvent the wheel. There is a department that exists. If the bill sounds unclear, it's because we're searching for collaborators and a pathway to create those conversations. But we can't fix this if we're not at the table. This is the double-edged sword that we as foster parents live with every single day. And it's hard to determine how we can fit in when we've been told that we don't count. So I plead for your patience and have sent along, actually, Representative Linehan, I emailed this to you, and I apologize for not sending this committee in advance, but I didn't think it was relevant until you had so many questions about the bias training. I sent along this example of what the bias training entails. This was training that was proposed to Region 3, and it was even presented at a national conference to other states and was lauded, but it died on the vine here at home. It never made it past Region 3 leadership. So we're not politicians, we're teachers, we're coaches, we're health practitioners, we're moms, we're dads, we're foster homes, and we're searching. So we're just looking for some collaboration.
Thank you so much. I really am looking forward to reading that. And I have to say, in this committee, historically, we never believe that emotion is a weakness. Not for 1 second here. That's our strength too. So I am looking forward to reading that. It's hard to find the words because there's so much to look into, and you seem to really have a grasp of what we need to understand. And I think that's going to be helpful. I just haven't absorbed it yet. So I'm just not able to do that here today on camera. But you have my solemn word that there will be further discussions, because, like, believe it or not, most of us aren't really politicians either. We're just, we're public servants, and we're the ones that wanted to stand up and do this. So, and that is why that's like the thing that we find most about people who ask to be on the Committee on Children. This is not the biggest committee. This is not the one that gets the most press. This is the one that does the most important work. So I look forward to actually having you as a partner in this, and I am sure that other members of the committee will as well. So thank you so very much. And those conclude my questions. Let me just do one last check. Are there any other questions? Representative Wieslander, I knew that would get another one.
Thank you, Ms. Carlson. And I wanted just to follow up, and because what Chair Linehan was saying before is absolutely true, that you are giving us a lot to think about right now. I'm going to ask a favor, if it's possible, for a little bit more. we've had a number of advocates refer to the Parents' Bill of Rights, the Foster Parents' Bill of Rights, but I don't think we've really been given any specifics as to what that would entail outside the option of giving a stronger voice to foster parents and, you know, the specific request to look at the term intervener. If it's possible, would you be able to send the committee information about exactly what foster parents are looking to have in this Bill of Rights? Because it's important for us to be able to look at, you know, there's so many different statutes. There's so much overlapping regulation regarding this type of care. And the more time we have to look at it, the better the chances of getting things through, even if it's not now, sometime in the future. So thank you so much for being here today and also for your passion. And please pass along our thanks to everyone else that you are representing today. Thank you, Madam Chair.
Thank you, Representative. I'm so glad you're still on our committee. Are there any other questions? Seeing none, thank you, Ms. Carlson. You're free to go. I believe we had one person who we had, I just want to make sure if you can give me 1 second. Yes, Olivia Rinks. Have we had Olivia Rinks? Nope, she's still not here. Ms. Rinks, if you're somewhere where you can hear this, please know you can always submit written testimony to the committee. And with that, we are now adjourned. Thank